Hello, everyone, and welcome to Uncivil Law. By request of someone on the channel, I am going to be covering a case from 2011 dealing with homeless and their rights in Florida. This is a case of Anthony Cantron versus the city of St. Petersburg. In this case, the city of St. Petersburg was preventing homeless from using parks, loitering in parks, using it for personal storage, keeping personal effects in parks, and so forth and so on. So we're going to be reading a little bit about the situation in St. Petersburg, read a little bit about the law. So let's get started with this. In this 1983 case, 4 homeless plaintiffs challenged the constitutionality of 2 ordinances of St. Petersburg, Florida, and the enforcement of those ordinances. One ordinance, the trespass ordinance, authorized certain city agents to issue trespass warnings for specific city land, in effect, exclusion from the property on which the agency determined the warning recipient had violated a relevant law. The other ordinance, the storage ordinance, prohibits storage of personal property on city lands such as parks and rights of way, which you normally would think of sidewalks as being an example of a right of way. This case involves the complaint against St. Petersburg by the 4 homeless residents. The city has cited, arrested, or confiscated property from each of the plaintiffs for violating the trespassing ordinance, the storage ordinance, or both. The plaintiffs filed suit in district court seeking declaratory and injunctive relief. We want the district court to tell us certain things are true, and we want them to order them to stop. Fair enough. On appeal, plaintiffs argue that the trespass ordinance, both on its face and practice, violates the Due Process Clause, the First Amendment overbreadth doctrine, and right to intrastate travel under the Florida Constitution. So apparently the Florida Constitution gives you the right to travel within the state as an operative of Florida state law. Okay, fair enough. Plaintiffs' first 3 arguments on appeal are about the trespass ordinance. Briefly stated, the trespass ordinance authorized certain city officials, including police officers, to issue a trespass warning, which warns person on public property to depart from that particular property and not to return. After a person has received a trespass warning, if the person is found on the pertinent public property in violation of the warning, he may be arrested for trespassing. This section requires a warning as exclusions for limited times. The plaintiffs argue that the trespass ordinance is unconstitutionally on its face, as applied to plaintiffs, and as a violation of due process and the 14th Amendment. The Due Process Clause requires that deprivation of life, liberty, or property be preceded by notice and opportunity for hearing appropriate to the nature of the case. A Section 1983 procedural due process claim requires plaintiff to prove 3 elements: a deprivation of constitutionally protected liberty or property interest, state action, and constitutionally inadequate process. Plaintiffs have a constitutionally protected liberty interest to be in parks or other city lands of their choosing that are open to the public generally. An individual decision to remain in a public place of his choice is as much part of liberty as freedom of movement inside frontiers that is a part of our heritage, or a right to move to whatsoever place one's own inclination may direct. So you have a right to be places and a right to walk around. That's pretty cool. Whether or not this interest is a fundamental right for the purposes of substantive due process, a person may forfeit this liberty right by trespass or other violation of law. So remember, we're talking about state law specific, right? So other states may have other laws. If we were talking right to travel from state to state, interstate commerce or interstate travel, right? We'd be talking about the Privileges or Immunities Clause under the United States Constitution, but we're not doing any of that today. We're just talking about Florida law, Florida specific law. So Florida specific law says these things. Florida specific law can say pretty much anything it likes. And so one of the things the court says is, well, whether or not this is a fundamental right, we have some issues. So of course, some rights might be fundamental and other rights might not be fundamental, but still important, right? So freedom of speech would be considered a fundamental right. You might have other rights. I can't think of one. One might be like a right to drive on a road with a proper license, right? That might be an example. Maybe we call that a right, but it wouldn't be a fundamental right if it is a right. It would be something less. Normally we think of that like as a more of a privilege, but if we want to call it a non-fundamental right, I guess we could do that too. And there's some state law that says that sometimes. Sometimes they'll talk about the right to drive, but it doesn't necessarily mean it's a fundamental right. So like the law that applies to that, assuming we call it a right, is a little bit different than when it comes to freedom of speech, right? So like you can be your right to drive can be, for example, just completely removed, with sufficient process. Your right to freedom of speech probably not so much. So there are some differences between fundamental rights and non-fundamental rights, particularly when it comes to state law. That's the kind of thing they're talking about. But they're saying either way, it doesn't matter because you're entitled to some kind of process, because whether it's fundamental or not, it's a right of some kind, and so you have a right to some kind of process. The initial question we decide is not whether plaintiffs have forfeited a liberty interest by trespass or other violation of law, but what interest plaintiffs allege they possess and been deprived in the first place. That's a really good question. That is a good place to start, right? We don't want to know whether or not you have forfeited your right. First, we'd like to know, what is your right, like at all? What is it? That's a good place to start, yeah. The plaintiff's factual allegations that the city prohibited them from being in the city parks in general, and Williams Park specifically, on public sidewalks and at bus shelters located on public sidewalks, leads us to conclude there's more than a sheer possibility that plaintiffs have been deprived of some kind of constitutionally protected interest. Okay, fair enough. Therefore, some kind of due process is needed. And we must determine whether the section provides the constitutionally adequate process that is due. So the city says you can't go to Williams Park, you can't go to parks, you can't be on the street, you can't be in our bus shuttles, right? So that seems like, okay, there's some sort of constitutional right, might be Florida specific, might be a non-essential, non-fundamental right, but it's something. So we have to determine whether or not you've got some kind of process that would comport to what the Constitution would require. Maybe it's a lesser burden, but it is a burden all the rest. So did the state meet it? Let's find out. To determine whether the ordinance satisfies the constitutional requirement of procedural due process, we apply the Matthews balancing test. That is, identification of the specific dictates of due process generally requires consideration of three factors. First, the private interest that will be affected by the action. Second, the risk of erroneous deprivation of rights through the processes used, and probable value, if any, of substitute procedural safeguards. So, is there something we can do about it? It's always a good place to start, right? And finally, the government's interests, including the function involved and the fiscal and administrative burdens, that administrative burdens that the additional or substitute proceedings would provide. So how much money will it cost? What kind of burdens will it provide, right? So we want to know, what right do you have, what interest do you have, what error is there, and can we do something about it? And if we can, how much is it going to cost us? These are valid questions. So as we're weighing these things out, fair enough. Section 230 provides a lot of discretion to many different city agencies to issue trespass warnings for a wide range of acts. Given these warnings operate like an injunction, because basically it's a don't come back or we're going to arrest you, so that does sound injunction-esque, yes, the situation creates a substantial risk of erroneous deprivation of liberty. Yeah, okay, fair enough. So it's a trespass notice, basically saying, do this again and we'll arrest you, right? But it's being issued by a government, right? So it's like, it basically is kind of like an injunction. We have given you notice that we're excluding you from our property. If you come back, we're going to arrest you, right? Okay, so it's kind of injunction-esque. Now, if it were a private person doing this, we probably wouldn't care very much, because private people can generally do this, right? Your place is generally open for business. A person comes in, and you don't want to do business with them, and assuming you're not discriminating them based on a protected class, because that's not allowed, well, assuming you just don't like them in particular, you can give them a trespass notice and say, hey, person, I'm giving you a trespass notice. You are now barred from this property. If you ever come back, I'm going to arrest you. Fair. We've given you fair warning. But if it comes from a government, due process is implicated. The ease with which these trespass warnings may be issued is particularly problematic here because the trespass ordinance provides no procedural means for the warning recipient to challenge the warning. And that is a problem, right? We might have an ability to challenge the actual arrest for that, but we don't have the ability to challenge the warning itself. And again, it's coming from a government official. That's the operative issue here, right? There's a right to public land. It's coming from a government official. And I don't have any ability, apparently, to challenge the warning itself. There's no court process I can go to. There is no way for me to challenge this warning. That seems like a problem, right? The warning is the trigger that's going to make me arrestable in the future. So, I might want to challenge the warning. And again, it's coming from a government. So, governmental warnings comes with some sanctions sometimes. So I might want to say, hey, this warning is improper. So what is my ability to challenge that? I don't have one. We are not persuaded that the state form affords sufficient due process. These trespass warnings are intended to serve instantly as a kind of restraining injunction. Effectively, yes. The process available in state court as a matter of criminal procedure to contest the state trespass charge, if a trespass warning later is not heeded, is beside the point. A challenge to the charge does not equal a challenge to the validity of the warning. So yes, I might be able to challenge the charge. And one of my challenges might be the warning itself was invalid, right? I can't be violating it if the underlying thing was invalid, but it would be nice to be able to challenge it in the first instance. And I have no ability to do that. So the court's saying, look, there's nothing here to give you ability to challenge. It's not fair. You need some sort of ability to challenge. It might not need to be a lot because the stake here is relatively low. It's not a warning. It's not a deprivation of anything. So maybe it's a relatively low burn, but even that, like Florida didn't do. So that is a problem. Okay, I understand this. The way the city has allegedly applied this section against plaintiffs in this case illustrates some of the problems posed by the absence of review. In 2006, a police officer issued Cantron, a guy, a trespass warning for all of Williams Park and all city parks. Yeah, that the all of Williams Park is not super disturbing. All the parks is a lot more disturbing. That is a problem, yes, which will remain in effect permanently, which incidentally is not allowed because they have to be time limited. So there's a couple of problems there. This warning is an example of a trespass warning not authorized by law, which requires a warning only as to specific property where the violation occurred and for a limited time. But as the trespass ordinances were written, Cantron has been provided by the city with no way to contest the warning, or at least the scope of the warning. We conclude that plaintiffs have stated a claim, facially and as applied under the Due Process Clause, that the trespass warning lacks adequate notice. Fair enough, I understand this. Let's get into the other issue. Section 8-321 prohibits unlawful outdoor storage of, among other items, personal property including clothing or bedding, or on private property and on public property including public rights-of-way. Again, these would be streets, would be your classic example of a public right-of-way. So you can't keep your stuff on a public right-of-way. Okay. The plaintiffs challenge this part of the law about storage on public property. Under the ordinance, storage is broadly interpreted to include any action to place, store, park, display, locate, or set an item of personal property. So this I understand and I agree with on a personal level. So this is more a political opinion than a legal opinion, but I'll give it anyway, right? The public property is property of all the public in common. It is a public right of all the public in common. And no person can take personal ownership of public property. It's kind of the point, right? So to the extent that you're like trying to store personal stuff on public property, it's like, no, that because the logic of it would have to apply to everybody, right? If one person can do it, then every person can do it, right? Because that's the whole point. Like the whole thing about like rights or privileges is we apply them evenly to everybody, all else being equal. Many asterisks can apply along the way, but all else being equal, we each want to have equal justice before the law. So if one person has a right to put their stuff on public land, everyone has a right to put their stuff on public land, right? And then the public land would be a mass storage depot. Effectively, it would be a junkyard, to be quite honest about it, before too long, because we see how people operate, right? And so that's not going to fly. We want public parks to be available for public park purposes. We want nice lush grass areas for people to sit in and picnic in. We want paths for them to walk on and bike on. And we want people to play frisbee, and we want people to play baseball and enjoy nature and walk by the stream and so forth and so on. Right? So the idea that anyone would have the right to store their personal stuff on public land would necessarily detract from the purpose for which it was created, right? And so again, like to the extent that this would apply to anyone, it would apply to everyone. And that is like the homeless want to say, well, I have nowhere else to put my stuff. Well, that's a problem, but if we allow you to store your stuff on it, every homeless person would be able to do it, and presumably every person would be allowed to, because again, the homeless, as such as their rights are, have no more or no less rights than anyone else. No one has the right to store their stuff on public land. It applies to everyone evenly. And so it's like, it's your private stuff. You can't keep it here. We want our land. We want it to be usable for the purposes for which we constructed it. So like, I'm very sympathetic to this position. There's private and there's public. And if you're trying to use public land for private purposes or private land for public purposes, right, there's a real problem. So this I'm much more sympathetic to, and I understand on a practical level. We do want parks to be available. We want sidewalks to be available. We want sidewalks to be available for people to walk on. I have seen the tent cities, at least pictures of them from LA. At least to my mind, this is not desirable. Because people can't use the sidewalks because they're completely cluttered, and they don't create a feeling of safety either. Because there's all this stuff, and it creates a real problem and disease and all the rest of it, right? So there's some real problems. It's like the homeless might have issues, and maybe we should be doing more. But the idea that they have the right to keep their private stuff on the public land, which is usable for collective public purposes, they're using collective public purposes for an individual purpose, and that doesn't make sense. Because if we did it for one, we'd have to do it for all, and then the whole point is defeated. So it doesn't make sense. If pursuant to the storage ordinance, a city official provides a person with written notice that a person is unlawfully storing personal items on public property, then they must remove the items within 36 hours. Fine. Moreover, if a sign is posted on public property stating that unattended items may be removed immediately, then no additional notice shall be required and the item may be removed immediately. Unattended items may be disposed of, yes. Plaintiffs argue the storage ordinance is vague and unconstitutional on its face because it fails to define the terms of unlawful storage or fails to define the term of unattended or both. So here this is confusing breadth with vagueness. And it was something that's common among non-lawyers too. I see it all the time, where just because a statute is broad doesn't mean it's vague. Vague means you don't know what it is. But unattended, like, okay, is it a relatively broad term? Yes. Is it an unclear term? Not really. I mean, you're either attending it or not. I mean, it's pretty clear. It's pretty broad. Like, by the letter of it, if you leave it for 5 seconds, it's unattended. But okay, that counts. And so it might be broad, but it's clear, right? It's not vague. In bringing a facial challenge to an ordinance for vagueness, a party who engages in some conduct that's clearly proscribed that would be forbidden cannot complain of vagueness as it applies to other. So if you're going to bring a challenge, you can only complain about what is happening to you. Accordingly, even though this challenge is facial, we must determine whether the terms unlawful storage and unattended are vague as applied to these circumstances. If plaintiff's own conduct is clearly proscribed by the terms, this necessarily precludes a finding of facial vagueness. Right? So there's two different kinds of vagueness, on its face or as applied. And so basically it says, look, if it's not vague as applied, then it's not vague on its face, which makes sense. If we can look at it as applied, then there must be a facially understood reasoning, right? So it's clear because, you can't argue these positions. It doesn't make sense. In chat, Mosaic Task Force says, in UK, there was a case study that giving homeless free apartment was cheaper than paying police to constantly remove them. The number of homeless getting a job after this was not significant, but the municipality used less money on the homeless. Yeah, I'm not necessarily arguing for any particular solution in terms of these problems. I do generally think that you can't just throw money at the problem. I once read someone, I forget the context of where I read this, but someone was posting a list of here are things America could do to fix whatever problems. Here's how much it would cost. And this random list that was produced by this person, it was in a major periodical, so I assumed it was to be taken seriously. This article said that to cure the homeless problem in the United States would cost, I want to say the number was $80 billion, or maybe it was $120 billion, something in that neighborhood, right? To cure homelessness would cost $80 billion or $120 billion. And I said, BS. We could write a check for $80 billion and solve this problem for all time. No way is this going to happen. Not going to happen. No way. Because a lot of homeless have a lot of problems, and they tend not to be the best caretakers of apartments necessarily. Again, we want to speak in broad terms. So are there some homeless who would act responsibly? Sure. But if you go into any public housing anywhere in the United States, you can take notice that a lot of people do not necessarily treat it very well. This may be because they don't have respect for it because it's not theirs. It may be because of mental illness. It may be because of a lot of reasons. But they don't necessarily do it. And sometimes they do things in their property that create dangers and hazards to others in the community that cause more crime and other problems, right? So there are a lot of issues. So I don't think it's as simple as let's give the homeless homes and it would be cheaper. If it were, as in this particular case study, then I'd be all for it, right? Because we can be pragmatic about it, right? If we could just really, spend money to build shelter and it would be cheaper than enforcing otherwise, then that'd be great. But, I have my doubts as to whether or not that study really reflects that. I also have doubts as to whether or not that's a long-term solution, even in that area. I have serious doubts that it's a long-term solution everywhere. I've seen enough public housing projects in the United States to have serious doubts that, just building homes will cure the homeless problem. And even if it does, it would create a lot of other problems too. So I have many doubts along these lines. I don't think it's as simple as we write $100 billion check and we're done. I don't think that's going to work. No. For the plaintiff's unlawful storage argument, the term unlawful storage clearly prescribes, which is to say forbids, plaintiff's Reynolds' alleged conduct, and it's not vague. It's not vague. It's broad, but not vague. Reynolds placed several bags, blankets, and other personal belongings, more than she could carry, on a park bench beside her. Reynolds kept these items with her because she did not have access to shelter or a place to store. A police officer gave notice that the belongings were being unlawfully stored. Yeah, if it's more than you can carry, you're using it as storage. That's fair. Reynolds' conduct was clearly prescribed by a storage ordinance. Thus, the ordinance could be constitutionally applied as to them. So the homeless cannot store their stuff in public parks, which is, in my opinion, good because we want public parks to be used for public park kind of purposes, not as garbage dump purposes. Yeah. Given the health, safety, and security concerns, the city's removal, even immediate removal when the warning sign is posted, of unattended items on public property would not surprise a person of ordinary intelligence who left behind belongings unattended. Not for least reasons that, they might contain explosives or something, right? That is, it's not closely and plainly accompanied by someone associated with the owner of public property. A person can understand this, yeah. We cannot conclude the ordinance is facially void for vagueness as to the storage requirement because we cannot conclude it's impermissibly vague in all of its applications. So that is the end of our coverage of this case of Charles Hargreaves versus the City of Petersburg. In this case, we learned the City of Petersburg had two different ordinances in play. One ordinance allowed a city official to give someone notice that they couldn't enter a public park or other public space, and this was being abused. There were officers who said you can't enter any park, even though the statute didn't allow for that, for unlimited times, even though the statute didn't allow for that. And the court says, quite rightly, I think, that you should have some ability to challenge this process. It is a warning that puts you on notice. It might be improper. It might be, so you should have some ability to challenge it. This I do not object to. And the court also said that you can't use public parks or other public spaces, including streets, for public storage of stuff. That you have nowhere else to put it is a problem. But if we allowed you to do it, we'd have to allow everyone to do it. And we can't allow everyone to do it because then it would defeat the purpose for which we created it in the first place. These public assets are assets of the public in common. And so for you to try to convert them to private use, for whatever reasons you might have, that would be in defeating of the public use that we created them for. So both these decisions make sense to me. It makes sense as applied to law, makes sense as applied to policy. So that is the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.